Hi, everyone. I'm Jamie McGriff filling in for Jim Spiewak. Of course, we have been keeping close tabs on the Kouri Richins trial, and joining us now is former prosecutor, attorney Nathan Evershed. Thank you so much for being with us, and of course, not associated with this case as we are discussing it. Of course, a lot of moving parts, and so my first question is, how important is a witness like Cody Wright to the prosecution's case? There are a few key people, key players that we heard from today. We had Cody Wright, who was the longtime friend and business partner of Eric with C&E Masonry. And then we had Matthew Throckmorton, who was also questioned. He was the crime scene investigator. Then you had Detective Jamie Woody, Summit County, with Summit County, with investigations there. And then you had Todd Gabler, who was a private investigator. So once again, with a witness like Cody Wright being called to the stand, what is the significance of this and the importance of it?
So this would be one of the best friends of Eric Richins. He was someone that was a partner in their masonry business, and someone that was able to come in for the prosecution and kind of humanize who Eric was, share some thoughts about him, talk about some financial issues involving Ms. Richins and whatnot. But maybe the most critical thing is what didn't happen. The defense were trying to get in allegations that Eric had used some kind of illicit drug back in the day. And outside of the presence of the jury, the judge ruled that those allegations and that evidence is not going to come in, which kind of popped a hole in the balloon of the defense because they're really trying to go down that angle and that pathway that maybe Eric Richins actually accidentally killed himself. So really fascinating, about an hour evidence and argument on that issue, and the judge eventually sided with the prosecution that that evidence was not going to get before the jury.
How tough is it to prove something like this to the jury, or at least to present this in a way that's convincing enough for even the judge to say, okay, this has enough meat to it to present it before the jury and to bring it into the case?
I think the whole thing is a tough case for the prosecution because it's just there's so many aspects to it, and I think they're doing a pretty good job trying to develop all these things. So like a friend like Mr. Wright is someone you have to put on because if you don't, that really presents the defense with an argument saying, well, where's this guy? What did he have to say? Why did they bring this guy forward? All of these different things. And so they have to put out all of these pieces of evidence and all of these witnesses to come forward to really kind of establish their case of motive, which is Kouri Richins wanted to kill her husband, and this is how she did it.
Okay, and moving on to Matthew Throckmorton, the crime scene investigator. One of the things here is that the defense pointed out that handwriting analysis relies heavily on an examiner's judgment. And I guess the question here is, how strong is handwriting comparison as evidence in the court today?
It can be a really critical part of the prosecution, but it's up to the jury, Jamie, to make a determination as to, hey, do we think that this was a forged document? Do we think Ms. Richards actually forged this life insurance application for, I believe, $100,000 life insurance just days or maybe a week or two before Mr. Richards died? And so there were multiple examples of credible signatures by Eric Richards. And then there's the opinion of this one person, and that's all he is just one person offering an opinion that he believed that Eric Richards did not write that. And then it comes down to what the jury believes.
And when you have a witness giving these statements, do you think it could hold more weight in some instances than others?
Absolutely. I mean, with someone like this that has apparently a lot of experience in these kinds of analyses, it's something that the jury could really, really give some significant credibility to, or the jury could just toss it all out and just say, you know what, there's not a lot of science to this thing. For example, one of the things that the defense was submitting was that maybe he did sign it, but he was intoxicated at the time. I mean, isn't that true? Like, or something like that. And so there's a lot of different ways that the jury could interpret it. But given his background and credibility, apparently, the jury could give some weight to it and find that they believe that that was a forged signature.
And now talking about business computers, that was also testimony that business computers were removed from Richins' home shortly after Eric died and before law enforcement actually looked at them. So does that raise any red flags when it comes to evidence handling?
Yes, and this is certainly going to be part of the defense's argument is that you can't put a lot of credibility or stock into how this was all handled, that Mr. Richins' family or other people had a significant interest in like obtaining evidence and working through evidence and doing these things. They're creating, reasonable doubt as to what the weight of this evidence is and what this other private investigation was, and trying to hope that the jury will see enough of that to force them to conclude that there's a lot of real smoke to this whole investigation, this private investigation, and have them cast some doubt on it.
When we're talking about strategy with this, from your experience, planning, putting together a strategy, how far in advance, how much time goes into that? Of course, we have calling in key witnesses. That's one aspect of strategy. What are some other aspects, too, that you would expect to see at some point or that you've already seen that maybe the general public would not notice right away?
Well, part of the strategy for attorneys on both sides is to create a narrative and a story that's believable and that's understandable. And so what the prosecution is doing is that they're creating a narrative that Mr. Richins was poisoned and that he was poisoned for a specific reason, for motive, for financial gain, and to end the marriage, et cetera, et cetera. What the defense is very likely doing as well is that they're creating their own narrative that this was not well investigated, that this was something where people had an axe to grind, that evidence was tampered with, that people viewed things only a certain way. And so through many of these, that Mr. Richins may have had some kind of a drug issue. So they're creating all of these things, which is what defense attorneys can do, which is what they do, creating this understanding that this reasonable doubt that our client could be truly innocent because this wasn't well investigated or people have an axe to grind, et cetera. So that narrative, which was formed, I'm sure, a long, long time ago, is really directing the sides of both parties.
What do you think the prosecution was trying to accomplish by putting both the lead detective and a private investigator on the stand today?
Well, they have to put these individuals on the stand. I saw the private investigator, and they cannot move forward with the case without showing the private investigator to the jury. Because if they didn't, then it just gives a tremendous opening to the defense saying, well, where is this guy? What are they hiding? What are they trying to have this guy not show to the jury? So they call him, they ask him about it. Who are you? What's your name? What kind of role that you played in this case? And that's what a lead investigator also is involved in. They have to put forth people that actually found evidence that were involved in the investigation. If for nothing else other than to let the jury know that this is who they are, this is their background, and this is what they did.
Typically, when it comes to courtroom cases, especially with this particular trial, is it normal or is it common practice, for those who are not familiar with law, is it common practice for key witnesses that are called that it would be both the defense and the prosecutors, they would both be in on knowing who the people are that are being called?
Yes. And so what the parties have to do before the trial, they have to submit their exhibit lists, they have to submit their witness lists, they have to submit their notices of expert. And so it's not some kind of sabotage game. Everybody should know in the trial who is being called and, for example, why and how to contact these individuals as well. And so everybody has an idea as to what to expect.
And one of the things that I've noticed is that during many trials, of course, with the defense as well as the prosecution, you'll see them writing notes. For those note-taking moments, what is the goal?
The goal is to recollect. I mean, one of the things that happens over the course of many days, now many weeks of a trial, is that you want to refer back to what this witness said. And so you're kind of keeping your own notes. And how I do it now, how a lot of other attorneys do it in trial, is that you create just two columns of like what's been testified to, and then maybe something that I want to follow up with this witness as I'm going to be doing cross-examination or redirect, and just kind of make notes as to what you want to do with that witness. Then later down the road, you can refer back and just recall, what did that witness actually testify to? Because you can imagine, through dozens of witnesses, it's very hard to recall exactly what every witness has said.
And probably for the witnesses themselves, we're talking about an incident that took place, a while back. And so, even with some of the witnesses, I remember, in particular, Detective Jamie Woody saying that from the memory, stating or giving an answer to a question that someone gave, and I can imagine that can be challenging for the witnesses even to try to remember something that took place long before the trial began.
Yeah, and in a case like this, Jamie, with so many text messages, so many
Yeah.
reports, so many emails, so many documents, so many everything, it's just impossible for the human mind to recall everything. And so it's important to have notes, and it's important to document appropriately.
Okay. And um, from what you saw today, who, in your expert opinion, gained more ground in court, the prosecution or the defense?
Well,
What did they use, in your opinion, that helped in putting their story and their narrative in a position that would maybe help with the jury making a decision down the road?
yeah, I think the prosecution won big on the lack of evidence that the defense really wanted to be brought in through Mr. Richins' friend, Mr. Wright. They were trying to explore that, and whatnot. And that was a big thing for the defense. They were quite deflated with that evidence was not able to come in. And I think that they knew that if there was a great possibility it wouldn't come in. But that was something that is a really strong legal argument on both sides about the rules of evidence and about prior rulings and all of this stuff. A lot of intrigue, but a significant win for the prosecution that stuff didn't come in. And now the prosecution, I think that they only have now a couple of witnesses left, and they're about at the close of their case. So no big blunders for the prosecution today. The defense had some strong points on cross-examination, but eventually this is going to turn over to the defense, and we'll see what happens with that.
Okay. And how would you advise a client to behave in her position, or in their position? I know a lot of people have been paying close attention to Kouri Richins as far as her demeanor and the color choice, what she wears, all of these things. What are your thoughts there?
Yeah, so the jury likely doesn't have a lot of experience with prosecutors or defense attorneys or police investigations or forensic accounting and things of that nature, but they do have a lot of experience with people. And
Hmm.
so it's so important for an accused person to look innocent, and so that doesn't respond to every small thing, that they're calm, that they're collected, that they're taking notes. And that's what I would advise my clients to do on the stand, that you're going to hear a lot of different things. You just have to be calm and quiet and make notes. And if you have any questions, we can talk about that outside the presence of the jury. But those jurors are going to be always looking at the defendant. It's just human nature. And you have to advise your client that they're always going to look at you. And so that would be a typical advice as to what would, and I'm sure that's been shared with Ms. Richins by her attorneys as well.
We still have a ways to go with this trial. Do you think that there could be some curveballs thrown at this point? I mean, we're almost through with the witnesses taking the stand.
Mhm.
What do you think there?
Probably not. Because what
Okay.
happens from here is that it's going to turn over to the defense, and the defense has the right to present their evidence, and they're going to do that. You don't see a whole lot of curveballs, though, with defense witnesses. At the end of the day, the state's going to be resting here, maybe even tomorrow, and they're going to be submitting and arguing that, judge, this is it. This is our case, and we got in what we needed to get into. And it's really that phase of the trial where the curveballs can occur. Now, because it's there where a mistrial could happen or something like that could happen from the state side, not really happening much on the defense side. And so we'll turn over to the defense, see what has to happen there, and see what evidence they're going to present and witnesses, and then it goes to closing. But I think we're through the trickiest part of the trial.
Okay. One one more question here, talking about the 911 call that was reviewed earlier this afternoon after the break. What are your thoughts about that? Do you think that having that evidence being presented, could that really hurt someone on either side with this case?
I think either side has their points on that. Certainly, the defense really likes that call, and we don't need to guess. They actually use that, or at least refer to that, in their opening statement,
Mm-hmm.
saying that this is the sound of a hurting widow, of someone that is grieving the loss of her husband. So you can hear emotion in that call, and the defense really likes that call. I'm sure that the prosecution is going to point out a couple of things that they may want to point out. I'm sure that might advance their narrative, to refer back to that again. But it's a critical piece of evidence. It always is. That 911 call, I'm sure it's one of the first things that the jury will be listening to and reviewing when they eventually get the case and go back to the jury room.
All right. Well, we, of course, will be keeping a close eye on this. And, of course, we thank you for your time once again, former prosecutor Nathan Evershed. Your expertise is very much appreciated, and I know that you will be listening in, and we will certainly have more questions as the days roll on. And pretty soon, all of this is going to come to a close. As far as the closing arguments are concerned, do you expect the closing arguments to be lengthy at all, or maybe just the average length of time to get their statements out? What do you think?
Oh, I think they're going to be incredibly lengthy. I think they're going
Yeah.
to be hours. There's going to be so much to refer to. And again, the closing argument is to go back to that narrative that I talked with you about, just saying this is all the evidence that supports that narrative and this view of the case. And there's a lot of evidence. I wonder if anyone's counted how many exhibits there are. There's just a ton. And so they're going to have to both kind of proceed with, this is why we brought this evidence in, because of this argument and what we're trying to present to you. So I think they're going to be very lengthy.
All right. Thank you so much for joining us this evening.
Thank you.